Ether, air, fire, water, earth, planets, all creatures, trees and plants, rivers and seas, they all are organs of God's body. Remembering this, a devotee respects all species. You know, this incredibly beautiful ancient philosophical quote from the Srimad Bhagavatam Mahapurana is actually how the preface of the monumental legal document we are looking at today begins. It's such a powerful hook because it immediately establishes nature as something sacred, and it introduces a core concept that runs through this entire debate we're going to unpack: intergenerational equity. It's the idea that, well, we just can't use up the Earth's resources at the expense of everyone who comes after us.
So let's dive right into this. Welcome to today's explainer. We are going to be unpacking a massive 260-page Supreme Court of India judgment. And this document tackles what has got to be one of the most significant dilemmas of our modern age. We're looking at this intense, really high-stakes tension between era-altering agricultural technology, specifically genetically modified or GM crops, and our fundamental need to preserve the environment. It is an absolutely fascinating clash between science, the law, and nature itself.
All right, here is our quick roadmap for today. We'll start with the GM crop controversy, move into the petitioner's core arguments, and then look at the alleged gaps in the regulations. After that, we'll examine the ecological risks, and finally, we'll wrap up with the guiding constitutional principles. Okay, let's kick things off with Section 1, the GM crop controversy. To really wrap our heads around this legal labyrinth, we first need to look at what actually catalyzed this 2-decade-long legal battle. What you're seeing here is the actual Supreme Court record for Writ Petition Civil No. 115, filed way back in 2004 by a group called Campaign against the Union of India, along with a few other petitions from 2005. Campaign is basically a society of scientists, economists, and environmentalists, so this is definitely not a new fight. These public interest petitions have been pending for literally years, fundamentally questioning how India handles genetically engineered organisms. But you might be wondering, why are we looking at this right now? Well, it's because of a very specific recent trigger. Enter DMH11, which stands for Dara Mustard Hybrid 11. This is a genetically modified mustard crop. The immediate spark that yanked these long-standing petitions right back into the spotlight was a decision made on October 18, 2022. On that day, the Genetic Engineering Appraisal Committee, or the GEAC, granted conditional approval for the environmental release of this GM mustard. That specific approval was the catalyst that pushed the Supreme Court to finally consider the merits of these decades-old arguments.
Moving right along to Section 2, the petitioner's core arguments.
So the petitioners, which includes folks like Dr. Suman Zahai, the president of Campaign, they are arguing that GM technology is this incredibly powerful emerging area of science. I mean, it lets scientists do things that were previously basically unimaginable, like taking genes from a bacteria and literally transposing them into a plant. Crazy, right? But because of the inherent uncertainty with that kind of tech, they argue that releasing GM crops out into the open simply shouldn't be permissible unless we have absolute rock-solid safeguards and regulatory regimes in place. They point out that while a lot of overseas jurisdictions have set up extremely strict regulations, India's current rules are falling dangerously short.
Which brings us to Section 3, gaps in the regulations.
According to the source document, the petitioners claim that the existing legal framework, specifically the 1989 rules framed under the Environment Protection Act, are basically riddled with holes. First up, they argue the rules don't even specify what qualifications you need to have to sit on these regulatory agencies. That leads to a heavy reliance on ex officio members who might completely lack the technical competence needed for complex risk assessment. Second, they cite a complete lack of transparency, like the public just can't access crucial safety data. Third, there's no requirement to get prior informed consent from local Gram Sabhas or even the farmers living right next to the field trials. Fourth, there's a huge accountability gap. Who actually pays the fine or goes to jail if a GM crop causes property damage or health issues? The rules don't say. And finally, and this one is highly controversial, the biosafety testing is often conducted by the applicant biotech companies themselves. The petitioners are throwing a huge red flag here, highlighting this as a massive conflict of interest, where companies are basically testing their own products behind closed doors.
Let's look at Section 4, the ecological risks. To really get what the petitioners are saying here, we have to understand the geographical context. GM technologies mostly evolved in industrialized, developed economies, right? And in those countries, farming usually means these vast, sprawling monocultures that are pretty isolated from wild ecosystems. But now, look at India. The petitioners emphasize that Indian farming is totally different. It's characterized by small, closely packed farms that often sit right up against or even inside natural forests. Plus, India is a center of origin for a lot of food crops, meaning it has these incredibly rich, ancient wild gene pools. So if you release a GM crop into a tightly packed Indian farming environment, the petitioners argue it is practically guaranteed to interact with the natural biodiversity around it.
Because everything is just so close together, the petitioners are sounding the alarm on some potentially irreversible ecological consequences. They're listing severe risks, like the transgenic contamination of non-GM crops and their wild relatives. They're warning about the creation of new, super hard-to-control superweeds if foreign genes transfer into the wild. They're also super concerned about toxins, like those from the beet gene, destroying vital microorganisms in the soil. And taking a step back from the biology, they argue this whole thing threatens the economic survival of small and marginal farmers. It could restrict consumer choice and basically hand over market control to just a handful of biotech entities. They're making the case that transgenic contamination is essentially unavoidable here, meaning GM and non-GM farming just cannot safely coexist side by side in India.
Finally, let's turn to Section 5, Guiding Constitutional Principles. So how on earth does the Supreme Court of India process all of these monumental arguments? Well, the absolute bedrock of the court's analysis is Article 21 of the Indian Constitution. As the document explicitly notes, the Supreme Court has consistently interpreted Article 21 to include not just a general right to life, but specifically the right to the health of the individual and the right to a clean and safe environment. This is a game changer because it means the court isn't just looking at this as a purely scientific debate. They are legally required to weigh this era-altering innovation directly against a citizen's fundamental, constitutional right to live in a healthy, uncontaminated world.
And to enforce that right, the court brings in something called the public trust doctrine. Citing a landmark case, MC Mehta versus Kamal Nath, the document explains that the government basically acts as a trustee for the public. They don't own nature, they just hold it in trust for us. Therefore, they can't just abdicate natural resources or ecosystems and hand them over for private commercial exploitation. The pristine glory of nature literally cannot be eroded unless the courts find it absolutely necessary, in good faith, for the greater public good.
Intimately tied to that is the precautionary principle. This is a massive, massive pillar of environmental law. The petitioners argue, and the court has to consider, that if there are reasonable scientific grounds to think a new tech might not be safe, you don't just roll the dice and hope for the best. Instead, the process should not be introduced until you have convincing evidence with reasonable certainty that it won't cause harm. If the potential dangers are serious enough, this principle legally justifies and sometimes even requires slapping a strict ban or moratorium on the technology until its safety is definitively proven. Which leaves us with this final, incredibly profound question to ponder as we wrap up this explainer. As science continues to race forward at lightning speed, how exactly can a nation balance era-altering agricultural technology, tech that could absolutely boost food yields, with the fundamental constitutional right to a healthy, pristine, and safe environment? It is a delicate, incredibly high-stakes balancing act between feeding the future and preserving the very earth we stand on. Thank you so much for joining me to unpack this fascinating legal document today. Keep questioning, keep learning, and I will see you in the next explainer.